I've already told you my bias in the past. If the city is growing simply as residential facilities and dwellings, then don't grow outwards, go upstairs, build multi-story buildings. I think because cities are not manufacturing, and that's why we're in the middle income traps, we should just insist that if you're not building factories, stay where you are. Don't expand your land. Yeah. So, but for dormitories, shopping malls, etc., go upwards. Don't go outwards. Yeah. But because of the highly compromised position of customary land, and because of poverty, this peri-urban land has become highly prized and with considerable gray areas in the way it's administered and converted to city land. So the challenges with African value systems around property rights, succession, and inheritance, as far as I'm concerned, is based on one single most important principle that is ignored by statutory laws. If we were to focus on this principle, I think we'll be able to revamp both our customary law system and integrate it properly into statutes. The main principle is this. In African tradition, one does not inherit property. One inherits responsibilities. So the mother has died, now this one is going to be the mother. This one is going to look after that one, all the dependent people. The father has died, you're going to be the father. Just because you're going to be the father figure does not mean you inherit the property. Responsibilities are going to be allocated first, and then property is distributed in accordance with the responsibilities inherited. And we can modernize that principle. We can take it to the highest state of social progress and ensure that what is family property is adequately captured in appropriate instruments such as family trusts and so on. And this is where women suffer most, because when there's gray areas, women suffer more than men because they're always compromised. In patrilineal communities or traditions, women marry into the husband's family. In multilineal ones, the husband marries into the woman's one. So in their patrilineal ones, the woman generally, when they get married, that's the time the young man also gets land. There's no land allocated to a young man before they get married. In my own clan, you don't even qualify for land. You bring somebody in through the family marriage systems, and when your wife comes in, then you qualify for land. Then they show your wife the land. You are not going to be shown any piece of land without a wife. So women have historically held very secure land rights within the traditional system. The intra-family rights were clearly defined. And at the time of divorce, that's where problems arise. But once again, the procedures were solid. Today, the procedures are lost. You see, the substantive aspects of the African law still rears its head here and there, but the procedural aspect is done, is finished, is broken down. So that's why men can take advantage, because you don't just divorce a woman historically. Today, men can just tell the wife to go away, and then that's that. Historically, you couldn't do it. The woman had rights both in the husband's family as well as the original family she comes from. Those two families that go through the entire procedures, which ensured that one way or other, the rights of that woman will be secured, both in a married family as well as original family, so that she doesn't become destitute and fall out. So the challenge is in that all this is lost. We no longer have a useful understanding and progression of African law. So the allocation of land rights under marriage in most of our countries has become a contentious issue, and it remains contentious under current legal frameworks, which They have no idea how to harmonize the understanding of what family and marriage is under African law and understanding of what marriage and family is under given colonial law. So in the case of Zimbabwe, and I've seen it in other constitutions, you prohibit discrimination on the basis of gender or sex. Yes, the constitution may say that, but then it does not provide full recognition of African legal traditions and legal systems. See, such provisions would be necessary to open up the needed reforms in African law. So both substantive aspects of the law as well as procedural aspects of the law, so that if the Constitution prescribes that there shall be no discrimination on the basis of gender and sex, the responsibility then falls on those who manage the traditional system to reform the system to abide with the law, given if there are any gray areas within customary law. That way, African legal traditions and legal systems will evolve over time, just like any other. Look at the English common law. There's no statutes. It was never written. Even the Constitution was never written, but evolves over time as society advances and is able to articulate a desired future. So I have a proposal on the pathway that eventually gets us to the parity of African law with colonial law. The first thing in any kind of problem, trauma, stress is to accept you got a problem. African countries, we have to accept we are in mixed jurisdictions, because just to give you an example of what I mean, we in Zimbabwe, like most Southern African countries, we ended up with Roman Dutch law, because Jan van Riebeck, when he came across the Cape and docked, you know what the history is. But what is Roman Dutch law? It was Roman law, which was then concocted with Dutch law, and mixed. That's already a mixed legal system before it even comes to Africa. So when it comes to Africa, why don't you add African law so that the mixture becomes Roman, Dutch, and African law? But no, you don't. You keep Roman Dutch law, and African law is just some kind of nuisance factor around it. So that's why I mean that the colonialization and post-colonialization process gave de jure independent African states this unwarranted enthusiasm in adopting Western legal systems and legal conceptions, forgetting that we need to develop our own legal systems. So the legacy of colonialism that brought Western civilization in terms of literature and formal schools also killed oral traditions and certain analogous values of our indigenous peoples that have deeply valuable if you want insights. So, and however, this phenomenon did not completely hinder us Africans. That's why we're talking about it now. The perpetual struggle is still here to maintain our legal identity as Africans. And therefore, we're beginning to see our constitutions being a bit more confident of just not subordinating customary law. But we have to go further. We have to go further. So any form of codification of African law is to make provisions for non-market land values, because the European laws or European commercial laws don't place much value on that. Social, cultural, religious, spiritual, or environmental values. Such provisions are important, especially for compensation of loss of customary land, whereas today, although there's bits and pieces in the legislation to say if people lose land under customary land, they might be compensated, it hardly happens. And quite often this goes beyond just losing the land to roads and other things. But there's a lot of land with serious religious and spiritual significance that just goes by and no compensation. So whilst substantive aspects of African law are important, I believe that it is the procedural aspects that have always been more important than the substantive aspects. See, because when the procedural aspects of the law are lost, it's anyone's game. The substantive aspects can be twisted around. And in understanding African legal traditions and legal systems and in trying to rebuild them, I would say 60 to 70% should be placed on the procedural aspects. This is where Africans were able to follow certain procedures that protected people, that included people, that ensured that the whole community would participate in decision-making, not just a small jury or just a judge on their own. So access to justice and dispute settlement needs a special place in such codified African law. Property rights, family inheritance aspects of law are all then central to African civilization. So the African law agenda is a very long-term agenda. It should not be a short-term agenda. We should have it a 50 to 100-year agenda. After all, colonialism was a 1,000-year agenda. We can't reverse these things in 10, 20 years. So here is where I think we would start. Here are some examples of how we would start this process. I think it would start with an agreement that universities, other scholarly entities, and other learned people sort of study the African legal tradition within our specific countries, trying to understand the local cultural world views around those legal traditions, asking questions such as what is law from our perspective, or what the value behind it, what are we trying to safeguard and what are we trying to promote. Secondly, then we put in place a process probably led by government, working with the legislative and legal fraternity and other citizenry groups to put together a long-term agenda on harmonizing African law within the mixed jurisdiction circumstance. Thirdly, you have the long-term vision and initially a 5-year or so plan enacted by Parliament into a national planning and budgetary process. And then prepare the universities and law schools and legal systems to implement such a plan. And the following is what I've gotten from the literature. I'm not a lawyer myself. I've never gone to law school, but I think you have figured me out by now. I don't need to go to any school. I'll figure it out. I'll try and figure it out for myself. I'm not always right or correct. I don't have to be, but I will tell you my best of understanding of the situation. What I've gotten from the literature is that you don't need to go straight into a fully Africanized law. There's at least 5 progressive steps we can follow. The first being at a national level, try a unification process where we look at groups of related customary laws, say within one ethnic group or related ethnic groups across nations. So in the case of Africa, some even spill over nations because we have artificial boundaries. But when you start by unifying the ones that are closely related within ethnic groups and kind of reducing and eliminating local variations to come up with the core essence, principles and values. Then the second step would then, it's now possible to go through a simplification process where rules and use of schemes designed to render the rules more certain and more accessible and more easily understood across the group and the groups. So because we've done it across related ethnic groups, then we simplify across ethnic groups. Then we can go for a modernization process where we take in contemporary improvements, addressing contemporary circumstances and changes in society, but still keeping the traditional value systems and principles. Then the integration of African law, and given colonial law that we have, it becomes possible because we have gone through at least a 3-4 step process of our own African law before we can try to integrate it with Western laws. Because at that point, the indigenous elements of law, both substantive and procedural, can be harmonized with a given law in all the branches of law, you know. And then finally, we will be able to see full Africanization of the law and its parity to all other laws, so that it becomes part of general law, not saying a given colonial law is general law when it only applies to 10% of society's understanding of life. So this is really what I'm proposing. And thank you very much for listening to me tonight.
Thank you. Thank you. Thank you, Prof, for your contribution. I now open up the floor for discussions and questions. Please use the reaction hand if you want to speak, and we'll give you the floor.
Hello? Hello?
Yes, Ms. Lovo, you can ask, yes.
Okay. Everyone, thank you for the opportunity to ask a question. I would like to the professor comment on what has happened in Zimbabwe. I'm calling from Zimbabwe. Into the community ownership trusts. This has been introduced by the government so that it was the government so that where there are natural resources that are benefiting people, when investors come into an area to mine, to actually make use of the natural resources that are there, like minerals, the community should also be part of it. But I realize that this hasn't been popular and it hasn't taken place.
Contributions?
Yes. So, okay, questions. Hello?
Hello, go ahead. Sorry, I think there's a bit of confusion, but you can go ahead.
Okay, yes, okay. What I want to know from you, Prof, is what's your take? Why has the community ownership share trust not taken off in Zimbabwe? Actually, nothing is happening in that area if you're following. What could be the reasons?
Sorry, Ms. Lovo, please just repeat the question. I think it just broke up for 2 seconds.
Okay, I wanted to know if the professor has been following up on Zimbabwe about the community share ownership trust that has been introduced by the government, so that the rural people can benefit from the minerals in their communities when an investor comes in. It hasn't been taken up because I think it's a very noble idea, considering what the professor said about creating middle income from the rural, middle income class, starting from the rural areas.
Thank you for that, Ms. Ndlovu. Is there anybody else who's putting their hands up for the next question?
I answer this one for now. Do you want me to answer this one as you're waiting for the next question?
Elton is he's unmuted. We're just waiting for him to ask his question.
All right.
Right. Okay. Yeah. Let me ask my question. I'm Elton Mujgajivi. I'm calling here from the Netherlands. I'm Zimbabwean. I've seen quite a lot of degradation cutting down of trees, I mean, more or less desertification in most of our communal areas over the years. And my question to the Prof is to say, does the Prof think that more secure land rights and more value being brought to the land could be one of the solutions to people beginning to value the land and really restoring its ecosystem functions and its productivity by reducing the degradation that is happening? Could that be one way of getting out of the spiral cycle of degradation that we are seeing in our communal areas? Thank you.
Thank you, Mr. Elton. Now we've got, I think we'll take the last question for this part. It's Ndai, if I'm sure. Yeah.
Thank you very much, Professor, for a nice presentation. My questions goes to urban encroachment to communal land. You have highlighted that there is encroachment of urban development in communal lands. How best can we manage that? We have realized that the chiefs, headmen, and individuals are selling this communal land to urbanites who wants housing land. How can we best manage this? Thank you.
I suppose I can just start answering these questions, right? So when it comes to community ownership trusts that were established in Zimbabwe at some point when we were pushing the indigenization agenda, there's a difference between externally driven attempts to organize people into trust as opposed to family-driven attempts to maintain and utilize family and community assets. So the community ownership trusts, although they were a progressive idea to a degree, they were externally driven solution entirely occasioned by big foreign investors who are mining or whatever in the area. And now you organize yourselves into community trusts so that you can benefit from what the commercial companies are doing. So it was not motivated by broad-based developmental activity in the community. It was driven by trying to benefit from what an external commercial entity is doing in your own area. So maybe you just also benefit from it. What I'm advocating is the communities organizing themselves before any foreign entity comes in. By foreign, I don't just mean outside your country, but coming from outside your community. Organize your community assets and your family assets so that families hold their own assets in their own trust. And then broadly speaking, a confederation of family assets constitute community assets, including common natural resource assets such as forest land, grazing areas, sacred areas, rivers, and so on. Now the community is ready to deal with anybody, you see, but having a community ownership trust being formed in a situation where the communities themselves actually have no community assets, they have no sense of a tightly organized community system of ownership and collective responsibility. It's just a reaction to outsiders. So although I would say it was a step in the right direction, still falls short of what I'm talking about. I don't know whether that makes sense to you. Then Elton, you're talking about this degradation that happens in the natural environment and whether secure land rights would make a difference. Definitely securing people and community land rights is the single most important in sustainable use of natural resources. So what happened in Africa generally is that the colonial governmental system assumed that the traditional ways of managing and owning natural resources and land was meaningless because it did not conform with their own legal traditions and legal systems. So they say the Africans are crazy. How can you have everybody belonging to everyone and the resources? They did not understand that those community-based systems were some of the best managed systems in the world. There was no environmental degradation. There was entire harmony with nature. Because the community owned the trees and the animals, and rules were put in place at community level to ensure that people did not abuse the environment. But it's the difference between that African legal tradition and systems and values is completely different to the industrialized Western one, in that the industrialized Western one, to then enforce the environmental laws, relies on police and courts of law, and people get arrested, they get fined, and so on. That's how you safeguard the environment. Under the African traditions, everyone is brought up in the community to love the environment and respect it. So people will walk in forests without any policeman looking at them or watching them, and they will respect the environment. It's because their conscience, it was their biggest policeman, not a threat of some policeman coming from outside your community to come and arrest you. So when people get their rights based on their understanding of their relationship to nature, their understanding of their relationship with property, they make the rules work for them and they will enforce them for themselves. When you take that away and you say that does not make sense, now we are now ruling you according to a given colonial law, it all falls apart. And it was no system of local government has been able to pull back Africans to where they were even 150 years ago, where the environment was tightly managed. Then there was a question on the native purchased areas, which was the attempts by the colonial government to push the title deed system on Africans. When I chaired the Land Tenure Commission in 1993-94, there was about 10,000 or so of those types of farms. They're all small farms, 200 acres, to no more than 1,000 acres. And although most of these farms that I looked at the time with our commission had been around for 50 years or more, less than 25% had converted their lease into a title deed. So as soon as the original owner, who was usually in the name of the father, because at that time the deed registry law, the deed registry law you registered the head of household's name. When that one passes on, then the children, so the sibling, and usually mostly with their widowed mother, remain and figure out how to share the land amongst themselves. And most never even convert it into title deed. So it's not about the title deed. Africa has proven that title deed is still a foreign idea. There's still family values. So when you go for title deed, it has to be on things that are so personalized and they are not family based. And today, the small scale commercials, although they did reasonably well in terms of wealth and produced generation of well-to-do Africans and well-educated, there was some social mobility that reduced the potential conflicts on the farm because a lot of the siblings did not want to stay on the farm, they moved on. It's not happening with our recent resettlement areas where most children are still poor, they still remain there, and they are still overpopulating the same piece of land that was allocated to their grandparents. Then Tentai was talking about urban encroachment. What's the best way to manage this? Well, there's a series of very obvious things that need to happen for us to better manage both the peri-urban areas and generally predict urban encroachment as it happens. First is the age-old idea of developing physical master plans for both the urban areas and the rural areas. You see, but somehow this has kind of fallen apart a little bit because if the economy is not firing, like I was saying, and there's no economic connection which is strong enough between the rural and urban areas, there's no manufacturing, so there's poverty in both rural and urban areas. Urban areas are struggling to provide services to their ratepayers. They can't supply the water, they can't get enough housing, there's not enough power, the health system is struggling. And you go to the rural areas, it's the same. So unlike orthodox structural transformation, you don't have progress in both rural and urban, you have poverty in both. So what happens is that the master plan system kind of also falls apart. And then eventually it is just, whatever happens. In some cases, there will be, in Zimbabwe, we've had a commission running on the land barons. It's a combination of corrupt city officials, corrupt traditional leaders, corrupt business people. I mean, it's just an opportunity to make money because the laws are porous and the procedural and administrative aspects are broken down. But I wouldn't be surprised if you were to go to our cities and found there is some kind of master plan, and then the rural district councils who surround the cities would also have master plans, but all that is not helped. Thank you.
Thank you, Prof. And please raise your hand for contributions or questions.
We've got Jekes, sorry, I think I'm butchering your name. Jekesai Jikizana has got a question for Prof. The question is, can we learn our future by looking at how the native purchase areas have progressed or developed in the last 60 years? There's always talk about how title deeds will or may turn around commercial farming in Zimbabwe as banks and insurance companies come to the party. Can anyone see a marked difference in success or failure of the farming systems in the NPA and the newly resettled farmers who's recently benefited from the land reform process? That is from Jikizana. The next person who is Alois. I'm going to lower your hand now. Alois Hungwe, you can go ahead.
Good day, Prof, and thank you very much for such a simple presentation. I'm not saying simple in order to minimize the value of it, but just to say you have brought things down to basic level, and I really like it. Thank you very much. I have always been fascinated and frustrated by the fact that we run parallel legal systems and they affect the way we manage our resources, not just agriculture, be it water or forest or anything. And your discussion, especially on the pathway to try and get us out of this, is what I found most interesting. You have articulated that we have to first of all accept that it's a problem, and we have a problem. And once we do that, we can move forward. However, I don't want to lecture on this, but I just want to say there's one aspect which I don't know if you had considered and which I wish we could look at, because you're looking at a long-term program, maybe 10, 15, 20, whatever. What do you see the value of incorporating this legal understanding, not education, understanding of our laws and incorporation of our traditional systems into law, being included in our education system right from primary and secondary and university, so that everybody can undertake this discussion of who we are, what we stand for, and how it affects the way we can move forward. And actually tying this out to your Mandi discussion, I can see this as one of the keys out of the middle income trap and the low income trap. Thank you.
Thank you, Alois. Can we have Abigail? Abigail?
Hi. Okay, good evening. Thank you, Prof, for the beautiful presentation. I always enjoy listening to you. My question is on the issue of the conflict between the farmers and the miners, right? I'm sure from what has been going on in the country, farmers are paying some tax to government, right? For a certain piece of land, depending on the number of hectares and all that. And then when the miner comes in, because of the superiority of the Mines and Minerals Act, they come in and start mining. What can be done to ensure that the farmer is protected from this, especially in terms of payment of tax? Because remember, the miner will come in and take part of the land that the farmer is paying to both the government and the Royalties Council. What happens? Can there be a position where the amount of land that the miner is using can be subtracted from the tax of the farmer? Thank you.
Thank you, Abigail. Prof, you wanna, before we had, there was a hand which was up, but I can't see it. So Prof, over to you.
Oh, sorry, it was Edwin Chizonga. I don't know if he still wants to ask, but we can give him 2 seconds to respond. If he doesn't, then I think Prof can just start answering. He can get into the next round.
Edwin, are you there?
Yes, I am. A very good evening to you, Prof. Mine is on a very light-hearted note, which is your spelling of the word African. You start with the C and end with the K. Was that deliberate or a mistake? Thank you.
Okay, thank you, Edwin. Over to you, Prof.
Yes, so let me start with a very good question around native purchase areas. Will the title deed do it? Or will the short and long leases under the new resettlement do it? So let me, at the expense of giving another short lecture, let me take the United States and China as examples. They're the two biggest economies in the world. And each one has been able to be the biggest economy in the world using completely different tenure systems. So let me start with the title deed system. The title deed system only works under the following circumstance. When the state acquires any land and now calls it state land ready to be distributed to people, they then offer these leases before they convert to title deed. Because if you give anybody an undeveloped piece of land, if you give them title deed, that piece of land can be undeveloped for 100 years. It can be used for speculative purposes. So the state normally does not give title deed to anyone until they've fully developed the piece of land. So they will give an intention to give you title deed or an intention to give you 99-year lease, but we give you 5 years to demonstrate you are a serious land developer. So then they check on you. Have you ring fenced the farm? Have you put in the roads? Have you cleared the land? Have you built in irrigation? Have you done what? Then when you have fulfilled those, then you can get a title deed or a 99-year lease, meaning the value is not in the land itself. Commercially, the land is in the improvements that you have put on the land. That's how a title deed system works. It works because you don't get the title deed until you have developed the land. But today, people just get a title deed and sit there and hope that it miraculously becomes a highly valuable property. Well, with speculation over time, the value may go up, but it doesn't develop the country. Let's go to the countries where there's no title deed and no need for title deed. So in this particular case, the state has a completely different relationship with the community. But in this particular case, the community knows that their land rights are secure. They don't need a title deed. They're even guaranteed certain services and support, such as strong extension systems. They will have access to credit. They will have access to markets, even some structured market systems where they are guaranteed markets or they are granted floor prices for their products. They are supported to be a serious business that supplies raw material to factories. And they boom, no title deed. So it's not about the title deed per se, but people of European and Western civilization, that's what they know. That's why they will preach that. But you talk to a Japanese or a Korean, South Korean, or a Chinese, absolutely no need for that. You can still have a fairly advanced economy. Then there was always on the pathway towards bringing back African law, even at parity within the general law system. You're absolutely right. The educational system is at the center of all this. And let me also just tell you on a lighter note what has happened to me over the last 12 months. Because I've been working on this idea for the last 12 months, 12, 18 months, because I'm considering starting some of this work in my own little, small little organization. And so and recently I've got a small project that started working on how to push fit for purpose land administration systems. And to be able to do that, you need to really start harmonizing African laws with the given laws. So I then started looking around for any experts in our universities on African law. I looked around. I found a few names, but I couldn't trace the people. Some of them are not in universities. I found around, and then I remembered, oh, I'm chairman of Great Zimbabwe University. And, you know, I would say, because I'm biased, we have got the best law school in the country, which we have really a brilliant law school. And I thought there must be someone in this country that they know who is a top African law expert. They could not give me a name. And I'm looking for a professor in African law. And if I would still break any bank and pay them whatever they want to be paid if I found one, because those are the people we need to transform the entire educational system, because education is the DNA of society. That's how you replicate your society. So if you don't have an understanding of African law in your law schools, how do you integrate African law? How do you codify it? How do you even go back to do research? Even researching into the African legal traditions and legal systems now requires top level academics, because what we have is not research into the legal traditions and systems. It's just a case of a look of what is quote unquote living customary law. In other words, what are they doing? That won't do it. So I'm pleased you raised that one, Alois, because I'm definitely working on that, and I know that many other people will join me, because without that, we won't be able to accomplish this even in the long term. Then Abby spoke about conflicts between the mining rights that then superimpose on farming rights or land rights of people in communal areas. You'll see this is happening mostly to people who are on state land. which is then offers usufruct rights either as communal or resettlement. It doesn't happen as badly on land that is held under title deeds, because with land that is held under title deeds, the courts have a right to intervene. So there's a lot more care that comes in, because anybody who wants to, quote unquote, go and prospect on a commercial farm, the procedure in place requires them to work in close proximity with the owner of that land. And in addition, the owner of that land, if the owner of the land indicates clearly to the Ministry of Mines they would like to prospect on their own farm, they get first preference. So that's why I'm pushing hard for the integration of African law into a general law system, so that family land, family trusts in communal areas and resettlement areas can be legal entities. They can also protect not just the land rights, but some of the natural resources on their lands. And at a community level, they can establish community trusts, not to please some foreign investor nearby so that they can build school for them, but to protect the resources in their community. And that's why I think African law has to progress now to make it possible for families and communities to, even under the ambit of the state, even if it is state law, they should be able to convert those usufruct rights to rights that can be protected and secured for them by the state. And the last question was at Edwin. Yes, I agree with you, Edwin. It was a mistake to have a C in Africa. Yes, it was a mistake. So I put a K. I put a K to hear what you think about it. But there you are. I've never come across any African language where you pronounce a C as K. The sound ka when you pronounce it in most African languages is a K, it's not a C. It will probably be Afrisa or Africha if you're going to pronounce it African. If you want to pronounce it African, you better put a K. But then there you are. Thank you.
Okay, we've got 5 minutes left for our session, so we'll take 2 more questions. One from Michael, and anyone else who wants to contribute, please raise your hands. Michael?
Thank you, Prof, for the opportunity to participate. In your presentation, you alluded to the fact that state land is public land, which implies that state land belongs to the citizenry or to the people of that particular country. But in the case of Zimbabwe, the paradox is that the head of state is the custodian of the land, which then implies that state land practically becomes government land rather than public land. How would we unpack that? I'm done. Thank you.
Thank you very much. Any questions? Any other questions? Please raise your hand. We have a question here from Peter Nkala. He's saying, Prof, please comment on the insecurity of tenure of both A1 and A2 fast-track farmers in Zimbabwe. What would be the best way to get around these insecurities to ensure the preservation and development of resettled land? Any more questions before we close up the questions for Prof to respond and close up the session? No other questions. Over to you, Prof.
Sure. The question around what is public land, state land, is yeah. You see what's happening here is that in Western countries where almost most of the public lands have been allocated to individuals and end up as private land. So don't forget that if United States, Australia, all these countries where the Europeans went and colonized, they would take the call it customary land there and then convert it into public land. And then they would offer it to citizens who would apply. Once they apply, they carve out a piece of land where they give them a lease with option to convert down the road to either a title deed or a long lease. That's how it gets private. It always starts as public. So they get a deed of grant. If they're the first one to get it, then it becomes a title transfer in subsequent transfers. And because they are now fully industrialized countries and 98% of the population is in urban areas, it does not make sense for the state to acquire them back. They only acquire back land they need for public purposes like Air Force bases and some environmental aspects and special areas and reserved areas and so on. But if you are not yet a fully industrialized country and the majority of your people are still rural, there's pressure on governments to keep declaring public land because you have to keep the option to allow more people to settle on that land. This is the danger of attempting to address the congestion of our rural areas just simply by hoping we can continue to subdivide land, because we'll never catch up. We'll never be able to decongest faster than the population is growing. The only thing that decongests rural areas faster than population growth rate is high economic growth rate and high industrialization rates. Sucks of people out into urban areas. So whenever we talk about public land, it is state land. It is administered by the state. So the only difference is when we talk about public lands, generally, we are looking at it being administered by a very elaborate system of public administration systems at national, provincial, and local levels. So it's public land being administered for use by other people. That's why we now refer it as public land administration. Whereas when the state acquires a piece of land because it requires to build an Air Force base, that is state land. In other words, the state gets the title deed to that land. So it's just a use of words here. The state head of state or president becomes custodian of it simply by virtue of the fact that they are head of state. That's why head of state is called commander-in-chief of armed forces. It doesn't mean to say they're gonna jump into the next aeroplane or gun and start firing the gun. They are just commander-in-chief, just like they are custodian of land. But that whole title of being custodian of all land, that is public land, is not different to being a commander-in-chief. It means you do have, as head of state, an elaborate system of public administration. Systems and institutions are organized, working at multi-level and multi-agent and capable of land governance and land administration that ensures that all different categories of land tenure, people enjoy land rights and they are protected and they can progress. That's what it means. But it does not mean the president is going to run and start allocating land, but they better have a seriously good public administration system. Then when it comes to A1 and A2 land in Zimbabwe, I always hated to to sound like I'm pessimistic, when in actual fact, I'm a fairly positive person. But what has happened with resettlement in Zimbabwe? Back in the early 80s, we had resettlement. And then in 2000, we started the fast track and created A1 and A2. The single most important thing that did not happen was accompanying the land redistribution with a seriously smart agrarian transformation. Allocating land, whether A1 or 2, it doesn't matter, but you allocate it specifically to locate and connect those farmers to the manufacturing sector and the commercialized supermarkets and other outlets and export. If you don't do that in the same stroke, you reallocate the land and immediately support those farmers through super services, access to credit, access to top quality advisory services which understand the market, not just old extension messages of master farmer, but people being connected to serious markets, being able to provide aggregation services that pull all the products of people into the right format, quality, and supply them to the supermarkets. All those services, if they are not there, it doesn't take 10 years. You'll have children born on that piece of land. They are poor, there are no jobs. And by the time they also have their own children, it's now territory for family. It's no longer commercial land. You remain poor and you are breeding poverty. That's what we have done. You immediately build a land bank when you start a land reform program. That does nothing else but build the capacity of land and farmers to be productive for the market, not providing working capital and buying tractors. No, to develop underutilized land and undeveloped land, roads, water, irrigation, so that they are productive and you supply factories and supermarkets. The other thing that would help is if the public exchequer was wealthy enough, is to persuade cabinet to offer reasonable compensation for people on A1 and A2 who are failing to meet the bill. So what you do is you don't threaten to remove them without some kind of compensation, but compensation is to be for the improvements they put on the land. So if somebody really fails to perform, they should be able to quickly get the option, hey, friend, why don't you leave? You are not a farmer. So, but your improvement on the farm is $5,000, we'll pay you and you go. Or they can voluntarily then approach government and say, I failed. Now I want, can you assess my improvements, pay me and I go buy a combi and do something else. I think those are the two things that would help to bring back A1 and A2 farms to a properly structured agenda to build a rural middle class and connect farming to the industrial processes and take us along a more sustainable path of structural transformation. Thank you very much.
Thank you very much, Prof, for your time and contribution. Powerful response there, powerful presentation. We are now closing the session. To all questions which were received in our inbox, Prof will respond to these questions which were asked during the session and the series via a short video which we'll upload on YouTube and share with you during the course of the week. To the Dialogue with Prof Mandi Rukuni technical team, thank you for putting this session together. Thank you, ladies and gentlemen, for joining us tonight. It was a pleasure having you. We are now moving the conversation to our WhatsApp group and to our Telegram group. As we close off this series, we'll be posting on our YouTube channel. Next week, we'll be moving a bit away from the land topic since it's Valentine's week. Our focus for next week will be relationships and culture. We'll share the topics of the week on Sunday, the 15th of February, where we'll give you our topics of discussion. Thank you once again. Good night, and let's have a chat in WhatsApp.